Welcome and thank you all for coming out tonight. We're pleased to have you here. My name is Amy Nabel. I am the director of Attorney General Healy's Division of Open Government, and my colleague Kevin Manganaro is with me tonight. We're going to be splitting responsibilities this evening, and we're going to be talking about the open meeting law. And I wanted to just start off by saying that this is an issue that's very important to the Attorney General. Government transparency is very meaningful to her, and she really wants us to make a lot of efforts to support you in your efforts to understand the law, to comply with the law as a citizen, to understand what your rights are as well. And so if you take nothing else away from tonight's presentation, I want you to know that we are here as a resource. And if we don't get to any of your questions tonight, you should feel free to call us afterwards. We have a hotline, we have an attorney of the day rotation, and we generally can get you answers within 24 hours. So we just want you to, at the very least, get to know us, and don't be afraid to give us a call. We are going to be taking questions. I'm going to collect the cards halfway through the presentation, and we're going to answer them towards the end. And if we run out of cards, certainly we'll take questions by a show of hands. Usually with a bigger group, we find, though, that things run a little bit more smoothly with the question card format instead of taking questions as we go. And then just one more caveat about questions. We can't comment on whether or not something that has already occurred is or is not a violation of the open meeting law. That's because we wear a couple different hats. One is training, one is enforcement. And so somebody could potentially file a complaint on it, so we can't tell you whether or not it violated the law. But we're happy to talk generally, hypothetically, about what the law requires and to try and help you on your way. So with that, what is the purpose of the open meeting law? Well, it tries to strike a balance between government transparency and government efficiency, and it does this in a couple different ways. It helps the public to know what their elected and appointed officials are doing by requiring notice of meetings, open deliberations that they can attend and witness, and public access. But it also recognizes that sometimes public bodies discuss things that are sensitive, and so it allows them to do certain business behind closed doors and to maintain the confidentiality of certain records of those executive or closed-door sessions. And we're going to talk quite a bit about executive session later in the presentation. Our role, as I mentioned, we wear a bunch of different hats. We educate and train public officials through regional training events such as this. We also create a lot of written materials. And if you haven't had a chance to visit our website, I encourage you to do so. We are pretty regularly posting new information to the website, including regulations, copies of all of our open meeting law complaints, all of our decisions that we've issued, and those are through our enforcement actions. And we also have FAQs, answers to frequently asked questions. We have checklists. If you haven't seen those, we have checklists on meeting notices, creation of meeting minutes, and executive session procedures, and we find those are a useful tool for people. And then finally, as I mentioned, we have a hotline. You can email us, you can call us, and we're pretty responsive. Like I said, most questions can be answered the same day. So here are the basic things we're going to touch on today. First of all, that notice has to be posted for all meetings, and we're going to talk about where the notice has to be posted and what needs to be in it. Meetings have to be open to the public unless the body enters into executive session. We're going to talk about the proper and improper purposes for executive sessions and the procedures that you have to follow if you do want to have a closed-door discussion. You have to keep meeting minutes. This is so that there's a record of what you discussed, even for closed or executive sessions, so that down the road, when those do become public, the public knows what happened in that meeting. There's a public body member certification process for all new and reappointed members of public bodies. We'll talk about that. And then finally, we're going to go over the open meeting law complaint process. And anybody can file one. It can be a member of the public, a member of the press. We even see members of public bodies occasionally filing against other members, though we do discourage that. So who does the open meeting law apply to? It applies only to public bodies. And a public body is a multi-member board, commission, committee, or subcommittee, however created, elected, appointed, or otherwise constituted, that's established to serve a public purpose. So the first thing to note about this is it's a multiple member body. An individual public official who's not serving on a public body is not going to be subject to the open meeting law. So the city manager, for instance, or town planner, if they're not serving on a board, they're just an elected or appointed official, they're not going to have to comply with the open meeting law. But it is a pretty broad definition, and I want you to note the second part, which is that it includes subcommittees. Subcommittees are any multiple member body that's created to advise or make recommendations to a public body. And it doesn't have to be called a subcommittee. We get this question a lot. I'm on a working group. I'm on an advisory committee. I'm on, this focus group. Well, most of the time focus groups are not going to be subject to the open meeting law, but what we look at is not what it's called. We look at how was it created, what are they doing, and who are they reporting to. So the level of formality. And so again, I encourage you, if you have a question about whether or not a particular entity is subject to the open meeting law, to reach out to us and we'll walk you through it, because they can be as varied as the stars in the sky. So again, the questions we're going to ask you: who created it? Was it created by law or by another public body to advise that public body? What do they do? Are they dealing with a matter that is a public purpose? And does it have a fixed membership? Are there specific people appointed or named to that group? And then finally, do they take collective action? Are they going to take any votes? Are they going to produce a report of some sort? And if it meets all those factors, again, it doesn't matter what it's called, it's going to be considered a public body. Now, there are certain statutory exclusions. The legislature and its committees are statutorily exempt from the open meeting law. Bodies of the judicial branch, bodies that are created by a constitutional officer, like the Attorney General, for instance, solely to advise that constitutional officer, are not going to be subject to the open meeting law. Bodies that don't serve a public purpose. So this is like your retirement party planning committee, for instance. It may be all public officials, but it doesn't serve a public purpose. Finally, groups that are not established with the jurisdiction to make decisions or recommendations collectively. And this goes back to what I was saying about focus groups. A focus group where you just invite 60 people and whoever shows up, and they're just going to be providing feedback on a particular issue, and they weren't statutorily created and nobody is requiring this group to meet. It's just whoever wants to come provide feedback. They're not taking collective action. It's generally not going to be subject to the open meeting law. And then finally, I was talking to someone about this before the presentation. There's the Connolly exception. This is a judicially recognized exception to the open meeting law that says where there's a public official who creates a group to advise that public official on a decision that he or she has the sole authority to make, that body is going to be outside of the open meeting law. In the Connolly case that the Supreme Judicial Court decided, there was a superintendent, had sole authority to pick the high school principal or middle school principal, and created an advisory committee to advise him on that. But the final decision remained with the superintendent. He wasn't required to create that body, and the court said that body wasn't subject to the open meeting law. So here are some examples of public bodies at different levels of government. There's an open meeting law advisory commission, advises us on regulations and training. Board of Library Commissioners, Board of Higher Education, charter schools. These are all state public bodies. At the local level, the Board of Selectmen, the City Council are bodies that are typically subject to the open meeting law. Boards of County Commissioners, regional school committees. Entities that are not public bodies, the State Senate and the House of Representatives, because the legislature is exempt. Certain bodies of the judicial branch, private organizations, the Mass Municipal Association and PTAs, high school boosters, those are all private organizations that are not subject to the open meeting law. Now, if an entity is a public body, the next thing we look at is what are they doing? Are they deliberating? And deliberation is a very broad definition. It was broadened when the law was revised back in 2009. And it's any oral or written communication through any medium, including email, between or among a quorum of a public body on any public business within its jurisdiction. So of course, the first thing I want to emphasize here is that email and electronic communications through things like message boards, Facebook, those can constitute deliberation. It's not important what the medium used is, it's who's communicating. Is it a quorum, which generally is going to be a simple majority of the body, unless there's some other statutory definition of quorum that applies. And what are they talking about? Are they talking about what it is that that body does? If they're talking about the weather, then it doesn't really matter. But if they are posting to a Facebook group And even if it's open to anyone and everybody, if it's a quorum of the public body and they're talking amongst each other about what they do, that's something that's impermissible deliberation. Those sort of communications need to be reserved for a meeting, and we'll talk about what a meeting is. Now, again, there are certain statutory exclusions to this broad definition. You can distribute certain documents. So distributing meeting agendas, scheduling, or procedural information is not going to be deliberation, and distribution of reports and documents to be discussed at a meeting is not going to be deliberation. But both of those carry a strong caveat, which is provided there's no opinion expressed. So you can distribute the meeting agenda, but you can't say, and I think it's really important that we adopt number 3. You can distribute a report and say, I strongly disagree with the conclusions of this report. You can't add that commentary, but you can distribute the report and say, here's the report that I'd like to discuss at our next meeting. We really discourage the use of email, and I know that this is a little bit different from how most of us operate in our daily lives, and it's a challenge if you're on a board or a commission, but it is so easy to slip up, even unintentionally, that it's really best to limit your use of email when you're talking to other board members to just these statutorily permitted purposes. And if you are going to email an agenda or document to all your fellow board members, we suggest that you do so using the blind copy function so that there's no risk that someone will inadvertently reply to all with some sort of substantive comment, and that's just kind of a best practice. Now, the next one on the list is something that we get a lot of questions about. Can a subquorum discuss matters within their jurisdiction? And the answer is yes. So if you have a 5-member board, the default rule is that the quorum is going to be 3. That means that 2 members can get together, they can talk about what they do as a board, and that's not going to be subject to the open meeting law. But again, there's a couple caveats. First of all, you have to make sure they're not a subcommittee. If they were asked to get together, the 2 of them, to discuss this issue, then if the parent body asked them to get together, discuss this issue, and report back, then it may have created a subcommittee. Even, again, if they didn't say, we're appointing you to a subcommittee, but they said, Joe and Mary, why don't you guys research this, talk about it, and come back with a recommendation, they're a subcommittee, they need to follow the open meeting law. The other caveat is that Joe and Mary can't then go to Mike, the 3rd member, right, and tell him what they discussed, because then you have a serial deliberation. If it reaches 3 people, if it reaches a quorum, even if it's not contemporaneous, then that could be improper deliberation. So you do need to be a little bit careful about that. Finally, this is a recently added exception, discussion of the recess and continuance of a town meeting in the event of a weather-related or public safety emergency is now something that is not considered deliberation for purposes of the open meeting law. So if you have a public body, if they are deliberating, they need to do so during a meeting. And a meeting is defined as deliberation by a public body with respect to any matter within that body's jurisdiction. This, again, as always, has some statutory exclusions. The first is any on-site inspection, provided there's no deliberation. This is if you want to tour a building facility altogether, you can go, you can tour it. What you can't do is talk about, whether or not you think that it's progressing the way it should be, whether or not you think that matters should be undertaken to speed things up or address changes. You can't substantively discuss it, but you can certainly go and tour, and it's not subject to the open meeting law. What we actually recommend people do is to schedule a meeting immediately after the tour. If they want to have those kinds of discussions, they can do the tour, take notes, and then go back, have a public meeting, and talk about it in as much depth as they want to. The next one is attendance by quorum at an event, such as an open meeting law training, provided there's no deliberation. So if all of the members of the City Council want to come to our open meeting law training, and they are certainly welcome to do so, they can all attend, they can sit in the audience and participate and ask us questions. It's not considered a meeting. What they can't do is all sit there in a row and talk to each other about what they do as a City Council. And so that's the caveat there. They can attend a meeting of another public body, provided there's no deliberation. So again, sit in the audience, participate on the same terms as members of the public. If that's the case, they don't have to treat it as a meeting. Meetings of certain quasi-judicial boards for the sole purpose of making a decision in a adjudicatory proceeding are also exempt from the definition of meeting. This is a pretty limited exception, though. It only applies to certain state public bodies. So zoning boards, boards of appeal, local boards of appeal are generally not going to fall within this exemption. And then finally, sessions of town meeting are exempt from the open meeting law. So if you have a meeting, what you need to do first and foremost is post notice so that the public knows the meeting's going to attend and that they can, the meeting's going to occur and that they can attend. Except in an emergency, notice has to be posted at least 48 hours in advance of a meeting, excluding Saturdays, Sundays, and legal holidays. So if you're having a meeting on Monday night, you have to post notice by Thursday evening at the latest. And the notice has to include certain things. It has to include the date, time, and place of the meeting. And it has to include a list of topics that the chair reasonably anticipates will be discussed at the meeting. Those topics have to be sufficiently detailed so that someone who's thinking about coming to the meeting can look at the notice, figure out what it is you're going to be discussing, and decide whether or not they want to attend. That means that if you are going to be discussing, for instance, a construction update, you should put what the project is. You should say, the school or the address. But if it just says construction update, members of the public have no idea what you're going to be talking about. So that's one level of specificity. Old business and new business are topics that we've generally said are not going to be sufficiently specific. If it's old business, obviously you know what you're going to be talking about, so you should put the specific items on there. If it's new business, that's a little bit more on the line. If your purpose in including new business is to have it be an opportunity for people to raise topics that weren't anticipated 48 hours in advance, then you are allowed to do that. You can have a public comment period. You can have a portion of the agenda that's saved for people to raise things that kind of came up that morning or during the meeting. But I think it's always a best practice to name it what it is instead of new business, unanticipated topics, or topics for discussion at next meeting, something of that nature. And we do generally discourage people from bringing up or holding substantive discussion of issues that weren't anticipated, but you can have a placeholder on the agenda for things that come up within the 48-hour period. Finally, the notice has to have the date and time that the notice was posted. And this serves a couple different purposes. It lets the public know that you complied with the 48-hour posting requirement, and it lets us know that if somebody files a complaint, that you have complied with the open meeting law. So it kind of helps you out in the event that somebody files a complaint. Now, there is an exception to the 48-hour notice posting requirement, and that's in the case of an emergency. Emergency is a sudden or generally unexpected occurrence or set of circumstances that demand immediate action. This is your quintessential water main break kind of situation, something that nobody anticipated would happen, and you have to take action right away for public health or safety purposes. In that case, where there's an emergency, you just have to post notice as soon as reasonably possible after you learn of the emergency. So here are some of the most, where did they go? All right, well, we'll get to my common questions. So if you post notice, if you have to post a notice, these are where you have to post the notice. For a local public body, it has to be posted with the municipal clerk. And the notice has to be posted in a manner that's conspicuously visible to the public, including persons with disabilities, at all hours in or on the municipal building where the clerk's office is located. Now, that's the default rule, but we've also authorized through our regulations certain alternative notice posting locations, the most common one being a municipal website. If you've adopted one of these alternative posting options, you don't have to post each notice to the default place, but you do have to have in the clerk's office available a hard copy of the notice, and you have to have visible at all hours a description of the alternative posting location. And obviously you have to notify our office of what that posting location is as well, so we have it on file. If someone files a complaint, we know what your posting location is. For regional and district public bodies, the default rule is that notice has to be posted in each and every city and town within the region in the same manner as for local public bodies. That means that If you miss one of them, then you haven't complied with the open meeting law's requirements. And for larger regions, this can be very challenging, so they may wish to adopt an alternative posting method, which is to post to a website. And again, you just have to notify our office of that. For state public bodies, you have to post to the body's website or the website of its parent agency and notify our office of the website where the meeting notices will be posted. We don't need to receive copies of every meeting notice. We would prefer not to receive copies of every meeting notice, but if you would like to send them to us, that's fine, we'll keep them. But you just do need to tell us where you're going to be posting notice, and you do have to send a copy of each notice to the Secretary of State's Regulations Division. So here are my common concerns. Here are a couple of questions that we get pretty frequently about notice posting. First of all, what happens if a new topic arises after the notice is posted? And as I mentioned before, the notice has to list all items that were anticipated 48 hours before the meeting. But things do come up. Things happen the day of the meeting that need to be addressed right away. And you can discuss it if it wasn't anticipated 48 hours in advance. But if you learn of it before the meeting, we encourage you to update the meeting notice so the public has as much notice as possible that you're going to be discussing it. And if it doesn't need to be discussed at that meeting, and if it wasn't on the notice, obviously the best practice is to postpone discussion until it can be properly noticed. We discourage posting notice so far in advance that you don't know what you're going to be discussing. So we know that historically, certain bodies would post an entire year's worth of meeting dates, just so that the public would know these are the dates on which this particular planning board is going to be meeting. And that's okay, you can still do that, but the risk there is that that doesn't count as a notice because it doesn't have the topics you're going to be discussing. Now, if you want to do that as an FYI and then closer to the date of the meeting, supplement with a notice for the particular meeting that has all the required information, that's fine, but the risk is that people do tend to forget. They post the year's worth of dates and then they forget to go back and supplement it. So just something to be aware of, to try and post your notices maybe a week or so before the meeting so that you have a pretty good sense of what you're going to be discussing. Another question we get a lot is, what if my town clerk can't post the notice in time? Now, the clerks are the partners of the public bodies. As I mentioned with the local public bodies, the clerk has responsibility for posting the notice, but the ultimate responsibility for complying with the open meeting law is on the public body. So we really encourage chairs to be aware of the town clerk's schedule, to work with them, to factor in, if they're on summer hours, if they don't work on Fridays, to factor that time in so that you're not getting it to them at the very last minute, because if the clerk can't post it in time, the responsibility for complying with the law is ultimately on the public body. We also get a lot of questions about canceling meetings. You do not need to give 48 hours notice to cancel a meeting, you can just cancel it. But as a best practice, what we recommend people do is that you post a notice to the same place where you posted the original meeting notice, letting people know that the meeting has been canceled. Maybe put a sign on the door of the meeting location so that anybody who didn't see that, who shows up, knows that it's been canceled. And another thing to remember is that if you do cancel a meeting, you do have to post a new notice to reschedule the meeting. You can't just have it. And if you're continuing a meeting, and this happens from time to time, a discussion's running long, you can't just continue a meeting from one night to the next. You need to hold a new meeting that is properly posted. So sometimes what public bodies will do is they'll post notice for 2 meeting dates in a row, and then if they don't need the second one, you can just cancel it. You don't have to give 48 hours notice, but that gives you a little bit of that flexibility if you think that a discussion is going to run long. Finally, we remind people that other laws, like the public hearing laws, might apply. Sometimes there's a public body that conducts public hearings, and they need to post notice in the newspaper and notify abutters and things like that. And those laws are in addition to the notice posting requirements of the open meeting law if this is a public body. So just be aware of that. A note about accessibility. So public bodies have to abide by all applicable state and federal laws governing accessibility for the disabled. If you have questions about making a meeting accessible to persons with disability, we really encourage you to reach out to our Civil Rights Division. They're fantastic about providing guidance on how to accommodate persons with disabilities. A couple other notes about accessibility. First of all, we get questions about meeting room size, and The open meeting law says that people basically have a right to attend and observe meetings. That means that we've interpreted that to mean that you should hold your meeting in a space that's reasonably sufficient to accommodate the expected number of people. So if you generally get 5 people at your meetings and you want to hold your space in a room, hold your meeting in a space that seats 10, that's probably fine. But if you know that an issue is particularly controversial and you have a larger space available, then you really should try to have the meeting in that larger space. But that said, if you know that you're going to have 1,000 people who are interested, the law doesn't require you to rent out, Gillette Stadium, for instance. Now, certainly if that's within your budget and you're able to do so, then we strongly encourage that, but you're not required to do so. You're basically required to make reasonable efforts to accommodate anticipated crowds. Also, we've had some questions and decisions recently about security policies. And you are allowed to hold meetings in buildings that have reasonable security policies, though certainly we discourage public bodies from using those kinds of policies to deter people from attending. But if it's a building that has a metal detector or you have to check in, generally it's going to be okay. But if you know that there are restrictions that people may not arrive prepared for, like for instance if they have to show a driver's license, that's the sort of information that, first of all, if you're able to hold the meeting in some place that doesn't have that restriction, that's always the better option. If that's your only option, then maybe put a note on the meeting notice so that people know in advance to bring their driver's license so they won't be turned away. So that's just kind of another piece of the puzzle there. So I want to talk a bit about remote participation. This is a newer aspect of the open meeting law. We issued regulations back in 2011 authorizing remote participation in meetings. But first it has to be adopted. And it has to be adopted by the chief executive officer in a city or town. So generally that's going to be the Board of Selectmen or the mayor, depending on the type of town. At the county level, the county commissioners can adopt it. And at the state level, the public body can adopt it on its own. So for the local and the county public bodies, once it's been adopted by the adopting authority, it applies to all the other public bodies in that municipality or that county, or all the other county public bodies. If they haven't adopted it, that means that it's not available. There is an exception to that rule, though, for local commissions on disability. This is another recent change to the law that says that local commissions on disability can adopt the practice of remote participation entirely on their own. So they just need a majority vote to do so. That means that, for instance, if the city of Cambridge hasn't adopted remote participation, but if it has a local commission on disability, that local commission on disability can still choose to adopt the practice just for its board. Now, there are certain minimum requirements. These are in the statute. First of all, remote participants and all people who are present at the meeting location have to be clearly audible to one another. A quorum of the body, including the chair, or in the chair's absence, the person who is chairing the meeting, has to be physically present at the meeting location. And then finally, members of public bodies who participate remotely can vote, and they're not deemed absent. And now again, there is an exception for local commissions on disability, specifically for the quorum requirement. They don't need to have a quorum physically present, they only need to have the person who is chairing the meeting present. So there does still need to be a physical meeting location, and the person chairing the meeting needs to be at that physical meeting location so that members of the public can come and they can hear the meeting. But all the other members can participate remotely. But that is an exception to the general rule, which is that you do need to have a quorum physically present at the meeting location, and the remote participants are just kind of a bonus. There are only 5 permissible reasons for remote participation, and these are personal illness, personal disability, emergency, military service, and geographic distance. And these are very broad categories. They're not defined, and there's a reason for that, which is that the chair makes the determination about whether or not it's unreasonably difficult for somebody to participate due to one of these purposes. So this kind of gives a little bit of discretion to the body to know what their own, what's reasonable for that particular body. For some bodies in the state, if somebody is, 20 miles away. It's geographically distanced for others. It's if the person's in Florida. So it's up to the public body to decide what they think is unreasonably difficult to participate. There are certain procedures that have to be followed, though, to use remote participation. First of all, the person who wants to use it has to notify the chair in advance that they want to use remote participation. Then the chair needs to make an announcement at the meeting that Joe is participating remotely, and then has to state the statutory reason for that remote participation. So they don't need to say Joe's participating remotely because he's at Disney World. They just have to cite, at the very least, the section of the regulations that says geographic distance, basically. If there is a remote participant, all votes need to be taken by roll call. This includes during an open session meeting, and that's because it's a little bit more difficult to keep track of what's going on. This is to create the clearest possible record when there's a remote participant. Remote participants can participate in executive session, but they do need to make certain required statements. And we encourage distribution of documents in advance to remote participants so that they can participate as fully as possible, because their votes do count. So acceptable methods of remote participation. It's very broad. It's telephone, internet, or satellite-enabled audio or video conferencing, or any other technology that allows the remote participant and the persons at the meeting location to be clearly audible to one another. And the public body can choose which method to use. So clearly audible, that means that you can't use text message, you can't use GChat or what other instant messaging formats. People need to be able to hear the remote participant. If you're using video technology, there's a requirement that the remote participant be visible to everyone at the meeting location, but it doesn't go the other way. So the remote participant doesn't need to be able to see the entire room. And then finally, the chair decides how to address technical difficulties. So if the person gets disconnected, the chair can decide whether or not they want to take a recess and try to get the person back, or if they're going to consider them to have left the meeting. I would just note, the public body determines which method to use, but the adopting authority gets to determine the amount and source of any payment for remote participation. So the adopting authority, it's an all or nothing vote. They either authorize it for all bodies or none of the bodies, but they can decide to only fund technology for, these two bodies. So finally, before I turn this over to Kevin, I want to talk a little bit about public participation in meetings. And the goal of the open meeting law is to ensure that the public can attend and see what their governing bodies are doing. But it's not an unequivocal right of the public to participate in the meeting. The public can attend, but they can't address the public body without permission of the chair or otherwise disrupt the meeting. Now, we encourage public bodies to give the public as much of an opportunity as possible to comment and interact and ask questions, but it's not required by the open meeting law. The public can make audio or video recordings upon notification to the chair and subject to reasonable requirements. That means that you can't tell somebody that they can't record a meeting, but you can say, you can't set that large whirring machine up right down front and block people's view. You have to do it in the back, or you need to have a quieter machine. The chair does need to make a statement at the beginning of the meeting that somebody's recording, and we've also said that if someone comes in the middle of the meeting and they want to record, then the chair should make an effort to let that person notify them so that they can tell people that they're recording. Because in practicality, a lot of people don't show up at the start of the meeting, they show up in the middle of the meeting, and we have interpreted the law to say that they still have a right to record. Finally, if a person continues to disrupt a meeting after a clear warning from the chair can order the person to leave the meeting, and if the person doesn't leave, the chair can authorize a constable or other officer to remove that person. Now, obviously, this is a last resort. We want people to know that this is a right that they have if somebody is being disruptive and won't calm down. But there are a lot of strategies you can use before it gets to this point, like, for instance, taking a recess, giving people some time to calm down, and then coming back and seeing if you can reconvene the meeting without having to remove somebody. So with that, I am going to turn it over to Kevin, and I'm going to come through the audience and collect any questions that people might have on this first part of the presentation, and then when Kevin's done, I'll address those questions.
Hello, everybody. Good evening. I think I greeted most people on your way in, but hello if I missed you, and hello again if I didn't. We're about halfway through, so I hope everybody's doing okay so far. I'm going to start by talking about the 10 permissible reasons that a public body can hold a discussion outside of public view. We call this an executive session. It's a closed session. It's held away from public view, as I said. So before we get to the 10 permissible reasons for an executive session, there are certain procedures that a public body needs to go through before it can convene an executive session. And that's what we see on this slide here. Before a public body can convene an executive session, they must first convene in open session prior to the executive session. For example, it's not appropriate for a public body to have an executive session from, say, 5:30 to 6 and then start their open meeting at 6 o'clock. You have to start in open session and then transition into the executive session. Before entering executive session, the chair needs to state publicly the purpose for the executive session in as much detail as went into the meeting notice. And we'll speak a little bit about this in future slides. But we look for the statement to include as much detail about the discussion that's going to take place in executive session as possible without sacrificing the legal purpose for secrecy. And we'll unpack that a little bit in future slides. The public body needs to conduct a roll call vote before entering the executive session and obtain a majority of the public body members. The public body needs to announce whether the meeting will be resuming in open session following the executive session so that members of the public know whether they should be sticking around, whether there will be anything else to see after the executive session. If there are any members participating by remote participation in the manner that Amy mentioned, they need to make a statement that no other person is present at the remote location and able to hear the discussion unless those other people have been approved to be there by the public body. Very critically, the public body needs to maintain minutes of the discussions that happen in executive session. We're going to be talking about meeting minutes a little bit coming up, but since this discussion is being held outside of public view, the executive session meeting minutes are really the only way that members of the public can know what discussion takes place in the executive session and whether it's proper. The public body needs to discuss only the matters for which the executive session was lawfully called. For example, if a public body holds an executive session to discuss a particular litigation matter, it is the chair's responsibility to keep the discussion on target to discuss only that. Obviously, human nature, conversations can wander sometimes, but it's the chair's responsibility to keep people on target. And the public body must conduct roll call votes for all votes taken during the executive session. So these are our 10 purposes for executive sessions. Don't worry, we're going to be diving into each of them in more detail. But I would just note at this point that this is a closed list. If it's not up here, it's not appropriate for executive session. So this is it. So we'll get started with executive session purpose 1. A public body may convene an executive session to discuss the reputation, character, physical condition, or mental health rather than professional competence of an individual, or to discuss the discipline or dismissal of or complaints or charges brought against a public officer, employee, staff member, or individual. So the first thing I would note about a Purpose 1 executive session is that, as it says, it is not appropriate to use this for an evaluation of an employee's professional competence. Those kind of conversations have to take place in open session. However, if you are convening a Purpose 1 executive session, say to discuss charges brought against a public employee, the person who is the subject of the executive session has certain rights under the law. And you see those listed here on this slide. The individual has the right to be notified by writing at least 48 hours prior to the proposed executive session. The individual has the right to request, if the individual requests that the discussion take place in open session, that request cannot be denied. The individual has the right to be present at the executive session that involved that individual. They have the right to have counsel present, not necessarily to participate in the discussion, but to observe and to advise the individual in the interest of preserving their rights. The individual does have the right to speak on his or her own behalf, and the individual has a right to create a record of the discussion that happens for future use. Executive session purpose 2 is to conduct strategy sessions in preparation for negotiations with non-union personnel or to conduct collective bargaining sessions or contract negotiations with non-union personnel. So I would just take this time to stress again that any discussion of an individual's professional competence, that has to happen in open session. For example, you can't use a purpose 2 executive session to perform someone's annual employee performance review. However, once that review is conducted in open session, how it factors into negotiations with an individual, that can be a part of a purpose 2 executive session. I would note the second bullet point here, when you are negotiating with a non-union employee, and an agreement is reached, the vote to execute the agreement needs to happen in open session following the executive session. You can agree on the terms while you're in the purpose 2 executive session, but the actual vote to execute, enter into the agreement, that would happen in open session after you reconvene in open session. And we see here that a public body should identify the non-union employee with whom it will be negotiating, provided that disclosure of this information would not sacrifice the purpose for secrecy. So this is a standard we're going to see come up in a few of the different executive session purposes, so I want to just pause and talk about it. If, say, a public body is entering into negotiations with Kevin, there may be reasons why disclosure of that information would compromise the public body's bargaining position with respect to those negotiations. We generally defer to public bodies. We give them the discretion to determine whether or not something will compromise their position. However, if it is challenged, say by an open meeting law complaint, and we'll talk about complaints a little bit later, the public body does need to have a reasonable explanation for why they believe their purpose for secrecy would be compromised by disclosing that information. Our next executive session purpose is purpose 3. This is to discuss strategy with respect to collective bargaining or litigation if an open meeting may have a detrimental effect on the bargaining or litigating position of the public body and the chair so declares. So I want to pause on that and the chair so declares piece, because this comes up in a few of the executive session purposes. This is the first time we're seeing it, that the law requires an affirmative statement by the chair of the public body prior to entering executive session. The chair would say, well, we are going into executive session to discuss X litigation matter because discussion of this topic in open session will hurt our litigating position. If you are using a purpose 3 executive session to discuss a litigation matter, it must be a pending or imminently threatened litigation matter. It needs to be demonstrably likely. So for example, it is not enough to have a purpose 3 executive session simply because someone else has hired legal representation, or just because someone else has the right to appeal a particular decision. We look for the litigation matter to be more proximate than that, more immediate. If you are using a purpose 3 executive session for the purposes of collective bargaining, you may, this is unlike purpose 2, you may approve the final terms of the collective bargaining agreement in executive session. So whereas purpose 2, you can agree to the terms, but then you have to execute it in open session. Purpose 3, you can do the whole deal in executive session. However, when you resume in open session, you should state that you have entered the agreement. You don't have to vote to execute it in open session, however. And once again, we see our rule that you should disclose as much information about the anticipated discussion as possible without sacrificing the purpose for the executive session. So in this instance, we would look for you to disclose the name of the litigation matter, unless disclosing that information is going to compromise your litigating position, or the name of the collective bargaining unit, unless disclosure of that information is going to compromise your bargaining position. 4 and 5 are pretty easy, so we don't have standalone slides for those. Purpose 4 is the deployment of security personnel or devices. This comes up only in a few circumstances, something like the placement of security cameras or where security staff will be located along a parade route, something like that. Purpose 4 executive session is not appropriate for discussion of police matters, generally discussion of police contracts, things like that. That's not what a purpose 4 executive session is. Purpose 5 executive session is for criminal misconduct. This is where a public body is considering the referral of a particular matter to law enforcement. Now, if that is the case, the individual who is the subject of the matter that's being referred to law enforcement in a Purpose 5 executive session, you don't have to notify them like you do in a Purpose 1 executive session. Because in this instance, you're not really discussing the merits of the complaint. You're really just voting to pass it along, say, to law enforcement. A Purpose 6 executive session is used to consider the purchase, exchange, lease, or value of real property if the chair declares that an open meeting may have a detrimental effect on the negotiating position of the public body. So Purpose 6 executive session is used for those limited purposes: purchase, sale, lease, or value of real property. This is not used for general land use matters, something like that. And once again, we see the requirement that the chair make an affirmative statement before going into executive session. And once again, we see the requirement that the chair should identify the piece of property that is going to be discussed unless doing so would compromise the bargaining position of the public body. Personally, I can foresee more situations where keeping discussion of real estate private would be understandable. If, for example, a municipality is interested in purchasing a piece of property, if that information is public knowledge, the value of that property can go up pretty quickly, which would hurt the public body's bargaining position. So that's one instance of where something would be appropriately withheld from disclosure on the meeting notice and in the statement prior to entering executive session. Just a show of hands, am I talking too quickly? No. Okay, I'm sorry. I'm from New York, so I have a tendency to just kind of go pretty rapid fire. Oops. A Purpose 7 executive session is to comply with or act under the authority of any general or special law or federal grant and aid requirements. So what we're looking for here for a Purpose 7 executive session is some law or other authority that requires something to be kept secret. For example, in the state's general laws, there is a provision that discussions of tax abatement applications be kept confidential. So that is the kind of thing that one would invoke. We are going into Purpose 7 to comply with this law that requires we keep this discussion confidential. Now, this does require that the public body cite the law, the statute, or the authority that requires the discussion be kept confidential. So for that reason, we encourage members of public bodies to consult with counsel before calling a Purpose 7 executive session, because it does require the determination that a law does require secrecy. And once again, even though the law in question would require secrecy, we just look for disclosure of as much information as possible about what the public body plans to discuss in the executive session. Purpose 8 is a little bit different because it doesn't concern a public body itself. It anticipates the creation of a screening committee. So Purpose 8 is to consider or interview applicants for employment or appointment by a preliminary screening committee. If the chair declares that an open meeting will have a detrimental effect in obtaining qualified applicants, provided, however, that this clause shall not apply to any meeting, including meetings of a preliminary screening committee to consider and interview applicants who have passed a prior preliminary screening. There's a lot of language there, so we'll unpack it. Purpose 8 executive session anticipates that a public body has created a preliminary screening committee to consider applicants for hiring. If you are creating this preliminary screening committee, there may not be a quorum of the parent public body on the preliminary screening committee. So for example, if you're a 5-member board, you cannot have 3 members who are also on the screening committee. 2 is great, 3 is not. You may also have other people on there who are not members of the parent public body itself. And when we talk about the preliminary screening in executive session, you can go through stages of applicants to whittle people down, but once you are down to 2, the final evaluation of those final 2 applicants needs to take place in open session. Now, it may be more than 2. You may say, the preliminary screening committee may say, we can't whittle it down more than 5. We've got 5 finalists and we can't choose any more. That final evaluation would happen in open session before the parent public body. And once again, we see the requirement that a chair make an affirmative statement that we are going into executive session for purpose 8 because discussion of these matters in open session is going to scare away qualified applicants. 9 and 10 we can breeze through. Purpose 9 executive session is to confer with a mediator on litigation or some other decision. In order to use a purpose 9 executive session, you already have to have the mediator. The vote to consult with the mediator in the first place needs to happen in open session, and purpose 9 is used to consult with the mediator once you've got him or her. Purpose 10 is fairly specific. Typically, if you are a member of one of these public bodies, you know it. It's to discuss trade secrets in the course of activities conducted by a public body as an energy supplier. This is a very select group of public bodies that act as energy aggregators or suppliers. If they're discussing trade secrets, they have a special executive session just for them. So those are your 10 executive session purposes. I would just stress again that any discussion that is going to take place behind closed doors needs to fit into one of these categories. The next portion of the presentation covers meeting minutes. The general rule is that public bodies need to create meeting minutes for all open and executive session meetings. And at a minimum, the minutes need to include the date, time, place of the meeting, and a list of members present or absent. The law says present or absent, but our office, we recommend, as a best practice, include list of members present and absent. Present members include Kevin, Amy. Absent members include whoever else. The minutes must also include a summary of the discussion that was had on each topic. So the law requires a summary. It can't be a transcript. Really what we're looking for here is a description of the discussions that took place in enough detail such that a reasonable member of the public could read the description and understand what took place. The minutes need to include the decisions that were made and actions taken during the meeting, including a record of all votes. And certainly if a decision is made and there are dissenting views, we would look for those dissenting views to be briefly summarized in the minutes as well, so that someone reading it after the fact could get a complete picture of what took place. I would note that secret ballots are explicitly not allowed in the open meeting law. The minutes also should include a list of documents or other exhibits used by the public body at the meeting. Now, these documents used at the meeting don't need to be physically retained by the public body. They don't need to be included with the minutes. They don't need to be stored with the minutes. They need to be listed on the minutes as something that the public body used, so that if a member of the public wants to make a public records request down the road, they will know specifically what to ask for. So I guess it's good to pause at this point and say, when is a document used at a meeting? Our office, in making that determination, we look to see if a document was physically present, verbally identified, and its contents are discussed. So if you have a particular report that you're considering, and you talk about it, you say, this is Kevin's planning report, and you talk about its contents, that would be a document that was used at the meeting, and we would look for it to be included as a listed item on the meeting minutes. And the minutes should also contain the name of any member who participated remotely and the reason that they did so, like Amy explained. So this is an overview of meeting minutes and other records and materials. The general rule is that meeting minutes need to be created and approved in a timely manner for both open and executive sessions. So while the law doesn't define exactly what a timely manner is, we look for, whenever possible, we encourage public bodies to approve their minutes of the first meeting at the next meeting. This is especially true for public bodies that meet on a regular basis. So for public bodies that meet, say, weekly, we would especially encourage them to try to approve their minutes from meeting 1 at meeting 2. However, when a public body, some public bodies only meet, twice a year, they get a little extra leeway. We spoke about the second bullet point a little bit ago, but documents and other exhibits used by the public body do not need to be physically stored with the meeting minutes. They just live as that little list on the meeting minutes, and then if someone wants to make a public records request down the road, they can do so. If a member of the public makes a request for open session meeting minutes, the public body must provide them whether they or not they are approved or still in draft form within 10 days. It's a little different for executive session minutes, and we'll talk about that on the next slide. Basically, executive session meeting minutes should be disclosed when the purpose for secrecy no longer exists. So let's say that you convened an executive session under Purpose 6 to discuss the purchase of real estate. Once the deal has gone through and your public body has purchased the particular parcel, the deal's done, your bargaining position can no longer be harmed by the knowledge that you were having this discussion about purchasing the parcel of real estate. Therefore, the reason for secrecy under the open meeting law would have expired, and those minutes should be disclosed. The final bullet point here is about the Secretary of State's municipal records retention schedule. That is something that we encourage members of public bodies to consult. It gives you an idea of how long certain records need to be retained. But the next slide says a little bit more about these executive session minutes. So the public body has the obligation to review meeting minutes periodically, executive session meeting minutes, I should specify, periodically to make sure that they are still appropriately kept secret. So for example, you would be going back to see, did I have a Purpose 6 executive session? Is the real estate deal done? If so, they can be disclosed. The law doesn't define precisely how often these periodic reviews need to take place. Certainly, I would recommend that they happen a few times a year, maybe once a quarter. It also depends on how much of a backlog of meeting minutes you have. Certainly, we encourage public bodies to be dedicated about going back and reviewing them. If a member of the public makes a request for executive session meeting minutes, now you may have gone back and reviewed them, and you've seen that the purpose for secrecy is still valid, so this is not subject to disclosure. Within 10 days of that request, you should respond to the person who requested the minutes and say, we reviewed the meeting minutes on X date, the purpose for secrecy still exists. If you have gone back and reviewed them and the meeting minutes the purpose for secrecy has expired, you should respond to them within 10 days stating that the meeting minutes are available and you should provide them. If you have not yet gone back and reviewed the meeting minutes, you should, the law requires that you review them at your next meeting or within 30 days, whichever comes first. You should also respond to the person who requested the executive session minutes within 10 days, letting them know that you got their request and when the meeting minutes will be reviewed. And then once you review them and that decision is made, follow up with the requester to communicate your decision. Whether, yes, we went back and looked at these, they're good to go, or no, we've decided to still retain them. There are certain categories here that are exempt from disclosure under the law. The first is materials used in a performance evaluation of an individual bearing on his or her professional competence that were not created by the members of the public body for purposes of evaluation. So if you are on a board and you yourself create a written document that evaluates someone's performance, that would be subject to disclosure. However, if you refer to a document that was created by a third party, and that document is a factor in your evaluation, that third-party document is not subject to disclosure under the law. The administrative complaint process that goes through our office. The first step in this is that the complaint is going to be filed in writing with the public body that is alleged to have violated the law within 30 days of the alleged violation, or if the violation could not have been reasonably discovered at the time it occurred, then within 30 days of the violation being reasonably discoverable. So whenever a violation occurs in an open session meeting, it is presumed to be discoverable at the time it happens. So if you're filing an open meeting law complaint related to something that takes place in an open session meeting, it would be 30 days from the date of that open session meeting. However, there are certain violations. Let's say something happens in an executive session. The public body releases the executive session minutes maybe months after the fact, and you say, hey, wait a minute, I don't think that discussion was proper for an executive session. You would file a complaint within 30 days of those minutes being released to the public. That would be when they were reasonably discoverable. And the complaint should be filed on a 2-page form that is available on our website. You can also ask municipal clerks to provide a copy for you. The second step is that the public body who receives the complaint has 14 business days to respond. The chair of the public body must disseminate the complaint to the members of the public body, and the public body has the obligation to review each open meeting law complaint that comes in. Now, it is not appropriate for a complaint to come in and for, say, the chair of a public body to immediately respond, or for the public body's legal counsel to immediately respond. The public body may delegate the responsibility for responding to the chair or to legal counsel, but they first need to meet to review the merits of the complaint. And if the public body needs more than those 14 business days to respond, you can contact our office and request an extension. Yes, there's a question.
30 business days or 30 days total for a member of the public to complain to a public body?
So for the step one, the question was 30 days of members of the public to complain to a public body. So step one, those 30 days are calendar days. Step two, 14 business days. So now the public body has responded with the 14 business days. If the complainant is still not satisfied with any remedial action that was taken by the public body in response to the complaint, they can refer the matter to our office for further investigation. In order to be considered timely, the complaints need to be filed with our office within 90 days of the date of the alleged violation or of it being reasonably discoverable. I think this is an important one to note. We will not review allegations that come to us for the first time when it's referred to our office. If an allegation is not part of the original complaint that goes to the public body, we won't review it in the step 3 stage. And please note that in most circumstances, complaints filed with our office and supporting documentation are considered a public record. So this outlines what happens once the complaint reaches our office. We will send an acknowledgement to all parties involved, letting you know that we're looking into it. Our investigation typically consists of interviews, which are done informally, requests for documents, and we try to just get a picture of what took place. We determine if a violation took place, and if a violation did take place, whether or not it was intentional. We look at whether any remedial action that may or may not have been taken by the public body was adequate to address the violation, and we then move on to whether any remedies are appropriate. And in a future slide, we'll talk about what remedies our office can order. I would just note step 10 here. If a public body is dissatisfied with a determination issued by our office, they may appeal within 21 days. So what I've just explained is the complaint process that goes through our office. There is a complaint process that bypasses our office entirely, and it's called colloquially in our office a 3 registered voters suit. 3 or more registered voters may initiate a civil action to enforce the open meeting law in court. The complaint must be filed in Suffolk Superior Court for state public bodies, and for all other public bodies, the complaint should be brought in the Superior Court in any county in which the public body acts or meets. So here we see the remedies that our office can order if we do find an open meeting law violation. We can order immediate and future compliance with the law. That's typically a strongly worded warning where we explain what the law's requirements are to public bodies that may have been mistaken, and to clearly state the penalties that could come from repeating the same behavior in the future. We can compel attendance at an open meeting law training like this one. We can compel the release of minutes or other materials, documents that were improperly withheld, for example. We can nullify any action taken in violation of the open meeting law. We can reinstate an employee and make them whole. For example, if someone was terminated improperly during an executive session, we could order their reinstatement, and we can impose a civil penalty of up to $1,000 on a public body for each finding of an intentional violation. Now, those last three I just mentioned are what I would say the more stringent penalties that our office could order. If we are going to recommend one of those penalties, the matter would come before an administrative law judge who would hold a hearing on the matter. Our office can also order other appropriate relief depending on the circumstances of the case. So we have thrown a tremendous amount of information at you, but this is the big picture takeaway that we want people to have. Notice needs to be posted for all meetings 48 hours in advance, except if it's one of those narrow emergency situations. Notice for the meeting needs to include the date, time, place, and a sufficiently detailed list of the topics that the chair reasonably anticipates are going to be discussed at the meeting. Meetings need to be open to the public unless it is convened for one of those 10 executive session purposes that I mentioned. Minutes need to be kept for all open and executive sessions. They need to include a summary of the discussion that was had on each topic, and they need to contain a list of documents and other exhibits that were considered by the public body. We went over the certification process and the complaint process. In the complaint process, I would remind everyone the complaint needs to be filed with the public body first, if you're going the route that goes through our office, and there's the alternative complaint process in Superior Court. We do sincerely want to stress that there are a large number of resources available for people to consult if you have questions about the open meeting law. One of the easiest ones is just to get in touch with us. We have an attorney of the day hotline, Monday through Friday, 9 to 5. We do our best to get back to people within 24 hours. We also have our email inbox. You can email that. That address will be on the next slide, and it's also in your handouts. Available during our same business hours, Monday through Friday, 9 to 5. We do our best to respond to people right away with questions. The resources you see here are the ones available on our website. We have copies of the law, copies of the regulations, our office's open meeting law guide that we created. We have checklists that are really fantastic tools for public bodies. If you're going into executive session, you can check off the different procedural steps to make sure you've hit every one. We also have copies of our determination letters. This is since our office took over enforcement of the open meeting law, we have every determination that we've issued. It's over 600 at this point. I don't know how many it is, but it's a lot. And you can search through those on our website, and we will admittedly state that the search function on our website is not the most sophisticated thing in the world. So if there is something that you are specifically looking for, feel free to call, and we're happy to help you research it.